Good morning, friends. Today I will talk about Section 118 of the Indian Evidence Act 1872, which talks about the competency of witnesses who can testify before court. Now, Section 118 of the Indian Evidence Act 1872 speaks about the competency of witnesses who can testify before court. The said provision makes it clear that all persons shall be competent to testify before court, except a particular category of persons mentioned in the said provision. When it comes to person falling under that category, the court has to satisfy itself that those persons are capable of understanding the questions put to them and giving rational answers to those questions. A child of tender age has also been brought within this category. So it is now too well settled that in order to determine the competency of child witness, the judge has to form his or her opinion. While doing so, it is left to the judge to test the capacity of child witness by adopting any method, and there is no precise rule laid down to check the degree of intelligence and knowledge which will render a child a competent witness. A child will become incompetent only in cases where the court considers that the child was unable to understand the question and answer them in a coherent and comprehensive manner. Now, the entire law was discussed by the Apex Court in the case of Peer Mesh versus State. You can go through this, and a child witness will broadly fall under two categories. The first category is where the child is a witness to an incident, and second category is where the child itself is a victim and hence a witness for what the child underwent. In cases falling under the first category, the chances of tutoring the child cannot be ruled out, and hence the court must be very careful while dealing with the evidence of the child in those cases. However, in cases that are falling under the second category, a child cannot be tutored since it is incomprehensible for a child to understand a sexual act. Therefore, the child will be able to understand about the incident only if it had really gone through the same. That is the reason why the apex court had repeatedly held that the evidence of victim of sexual assault must be dealt with more sensitively, and it should not be appreciated in the manner in which the regular evidence is appreciated. So this was all about the child witness, and more particularly when the child is a victim of sexual harassment. I have taken the contents from the High Court at Judicature Madras. This was decided on 3rd April 2023, and the quorum was our Honorable Mr. Justice N. Anand Venkateshwar, Criminal Appeal number 245 of 2016 and 154 of 2017. So, in the last, I will thank you for watching and hope you will like and subscribe my channel.